count for anything?
3 credits.
All right.
You take over.
Ready?
Okay.
Yeah.
So I appreciate the 3 of you who decided to come today, but you'll have a good lesson, private tutor basically. So the 3 here, 54 absent. Very well. All right. Today's class, Covenants Part 2, considers some miscellaneous topics. What are they miscellaneous? The first case doesn't really fit anywhere, so I put it up first. Can courts enforce covenants that involve racial discrimination? The second 2 cases are somewhat related. How long do covenants go on for? Does it ever reach the point where a covenant is no longer valid? In other words, how can courts terminate covenants that were properly created? Okay, so any questions about this? I don't need to do the poll. It's too easy. I'll do the poll. Why not? Keep with tradition, right? All right. So here's your question, right? The Constitution only regulates state action. Okay, that's your question. 3 of you, so we should get a good split. True, false. Constitution only regulates state action.
Why is my poll not coming up? Mine's not coming up, but I'm going to go with A.
You know it's true? Okay.
Yeah.
All right, so. Wow, okay, so Lindsay said true, and the other 2 you said false. Now I know who's who.
Isn't it true?
What do you think, David?
Me?
What's state action? What does it mean to have state action?
In the case we read, it's like in the case we read, the court, like...
Someone left their lunch here. Uh-oh. Yeah, but what's state action?
Is it like the example in the case where like the court enforced that covenant that was racially restricted? Like, yes, you have to obey the covenant, and that was like a... I don't know if I can actually give you a definition, but like as an example in the case, they said, hey, you can only sell to white people, and the court in the judicial process, they're like, yes, you have to enforce this covenant, and action by the judicial branch was considered.
Okay. What's state action?
I'm not really sure, to be honest.
What did it discuss in Shelley?
In Shelley, it talked about, you may go ahead and just do the case.
No, I'm asking you, I don't have to tell you the case. What state action has discussed in Shelley?
State action would be like state court, judicial action, stuff like that.
Yeah, so in Shelley, it's judicial enforcement of the discriminatory covenants is state action, but state action is just any branch of the government acting, and that's what what we learned in con law, we did this big thing about state action. It has to be state action.
Oh, someone remembered.
Yeah, and then even in...
but what's state action?
Any branch of the government acting.
So the Constitution only regulates state action.
That's what I got from con law, but we only did the 14th Amendment, so...
What's the one that comes before the 14th?
First, second, third, what? Oh, 13th.
What's the
13th, yes, that's the only one that applies to private individuals, you're right,
Someone
yeah.
remembered con law, very good. So, I don't have...
Darn it, yeah, I forgot about that one.
Don't forget about 13th. So the 13th Amendment, I think I forgot to paste it up here. Show your Constitution is handy. Provides neither slavery nor involuntary servitude, except as punishment for a crime whereof the party shall be duly convicted, shall exist within the United States or any place subject to their jurisdiction. Right? What does that mean? Slavery, involuntary servitude, is prohibited. Now, is it only slaves owned by the government, or also slaves owned by private parties?
Slaves owned by
Private parties.
Exactly. So the 13th Amendment was the first provision of the Constitution that acted on individuals and not the government. There was a second provision. See if anyone knows it. You know the other provision that acted on private individuals? I'll give you a hint. Alcohol.
Or the prohibition.
Prohibition. So the 18th Amendment prohibited the manufacture, sale, or transportation of intoxicating liquors.
Al Capone.
Yeah, the mobsters, right? They were involved in the bootlegging business. Now, fortunately, the 18th Amendment has been repealed by the 21st Amendment. But those were the only provisions of the Constitution that apply to private actions. Now, the 14th Amendment, though, as interpreted by the courts in a decision called the Civil Rights Cases, held that only states are bound by the 14th Amendment. Right? Only states are bound by the 14th Amendment. So, this is column up, but you guys are here on the weekend, so I'll give you a little preview. I'm actually, by the cosmic fate of the universe, I'm teaching this exact same topic later this afternoon in column up. If you want to come by, you're welcome to double dip. The 14th Amendment has several important provisions in Section 1. The purpose of the 14th Amendment, in large measure, was to reverse the Dred Scott decision, which you may recall said that people of African descent could never be citizens of the United States, no matter what. Section 1 of the 14th Amendment expressly said that if you were born in the United States or naturalized in the United States, you are now a citizen of the United States and of the state wherein you reside. So states could no longer deprive people of citizenship. But then comes the next part. Okay? These three clauses were expressly designed to put limitations on the states. Now, the Constitution had some limits on the states. For example, states couldn't violate contracts. States couldn't impose bills of attainder, which is basically when you sentence someone to a crime by legislative act. States couldn't create ex post facto laws, which is where you criminalize something that was legal when it was done. But there weren't many limitations on what states could do. States generally had the full scope of their police power. But Section 1 of the 14th Amendment changed that. The first provision provides, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. This is a clause that has not gotten much attention, even though it should have. This was supposed to be the crowning jewel of the 14th Amendment. And what are these privileges or immunities? Various rights which the government cannot deprive you of. Among them, the right to own property, right to make contracts, and most likely the rights listed in the first 8 amendments of the Constitution. Yes, you learn about incorporation from the Due Process Clause, all wrong. It's supposed to be through the Privileges or Immunities Clause. However, in a decision in 1873 called the Slaughterhouse Cases, did you read that one? Good. In the Slaughterhouse Cases, the court held that this phrase, privileges or immunities, refers to a very small set of federal rights that don't have much significance that the state cannot violate. The second provision has gotten a lot more attention. It says, nor shall any state deprive any person of life, liberty, or property without due process of law. Now, the Fifth Amendment already had a due process clause, but it only applied to Congress. Now, the state can deprive a person of life, liberty, or property without the due process of law. The third provision also controls the states, that the states cannot deny to any person the equal protection of the law. What does that mean, equal protection of the laws? Well, today it generally means you have to treat people alike, regardless of their race, for example. That's probably not it was original understanding. It was more that they would protect people equally. Actual protection from state force. Think of the Ku Klux Klan and other groups. But the key element of all three of these provisions, as the court has long understood it, which is probably wrong, but as the court has long understood it, is that it only applies to state action. It only applies to state action. Okay? So what does that mean? Can private individuals, can private businesses engage in action that deprives someone of their property rights? Can a private individual deprive someone of their liberty? Must a private land sale comport with due process of law? Must a private land transaction comply with the protection of the law? Okay? And this arose in, of all places, the topic of covenants. The topic you probably thought was fairly boring and irrelevant to constitutional law, but had a very significant case early on in the 1950s. Or it was 48 or 49, I got the year wrong. Okay. Was it 48, 49?
48.
48.
48.
So, first off, the vote in this case in 1948 or 49, whichever year it was 6-3. I'm sorry, 6-0. 6-0. Anyone want to take a guess why the vote was 6-0 and why they didn't have all 9 justices participating? Anyone take a guess? Vote was 6-0, unanimous, no dissents. Why were only 6 justices participating?
Some kind of conflict of.
Oh, there was a conflict of interest, sure there was. Want to take a guess what it was? What could a possible conflict of interest be?
Were they
Why
like
just
living on a street, or they signed some of the restrictive covenants themselves?
3 of the justices had homes with restrictive covenants on it. Justices Stanley Reed, Robert H. Jackson, and Wiley Rutledge. 3 justices recused from this case because their homes were bound by racially restrictive covenants. In fact, at least Jackson lived in the District of Columbia. I don't recall the other 2 lived probably either D.C. or Virginia or Maryland nearby. And their land was controlled. So to give you a sense of how widely understood these covenants were, even the justices of the Supreme Court bought property with these sorts of covenants on them. Cool, right? Or not cool, but like, you know,
Yeah.
quirky. So I actually have a photograph of the house in Shelley v. Kraemer. It's outside of St. Louis in Missouri. And there's a little plaque in front of it that says the Shelley house. Okay, so David, you want to give me the facts here?
Shelley v. Kraemer. In 1911, there were 30 property owners
Okay,
on a street in St. Louis,
good.
Missouri. They signed and recorded a restrictive covenant because that said no race other than Caucasian.
Now, David, how many of the property owners in the block agreed to this deal?
I think it was, what, 30 out of 39?
30 out of 39, huh? So that means 9 of them didn't agree. David, putting aside constitutional law, right? We're in a property class. What's problematic about this covenant, right? Think back to our class last week. Why property law? Forget con law for a minute.
Mhm.
What's problematic about this arrangement?
Well, if one of those 9 that didn't sign the covenant did sell to somebody who was, for example, African American, then it's, you know, the others say like.
What was required for a covenant to run with the land and to bind future successors? What was required? What do we call that?
Privity,
What kind?
vertical,
And?
horizontal.
Okay.
Horizontal.
You need
vertical.
both, right?
Okay,
The
yeah,
common
sorry,
law.
horizontal and vertical.
Was there horizontal privity here under this arrangement? Only 30 out of 39 property owners agreed to this arrangement?
I don't think so.
No.
No. Mm-mm.
No. What was lacking? What had to happen to make horizontal privity present at that previous state?
They had to agree to the.
How? Under the common law, how did you have horizontal privity? It's a good review question.
If it came with the land.
Yes. You have to sell the land with the covenant attached. From the 3 of you, right? People watching at home in TV land, right? You guys remember this, right? In order to have a common law, privity of estate, what we call horizontal privity, you need to have a land sale. You need to have transaction. You couldn't simply convey the covenant in isolation. My exam question a couple of years ago was basically Shelley v. Kraemer under property law, right? Forget common law. This covenant wasn't valid. Only 30 out of 39 homeowners agreed to this arrangement. There was no horizontal privity. There was no privity of estate. It was not a valid covenant. In fact, I think the case explains at the time, 5 parcels were actually owned by African Americans. And about 7 or 8 of the houses didn't sign the covenant. No surprise, right? So this covenant was not valid as a covenant. Now, Lindsay, what about as an equitable servitude, right? We already said we don't have horizontal privity here. But could a court enforce this as an equitable servitude?
I honestly don't really know the difference between
Well,
equitable
this is a good time to review,
equitable
isn't it?
servitude and easement and all of this, and you said you were gonna give us it
Well, I'm
on
telling
the
you.
exam, but
What if
I'm assuming you don't need horizontal privity or any privity whenever you have it.
Just one step at a time. Well, what I said was, I'll tell you on the exam what this is. So if I gave you the exam question, I would say, we call this an equitable servitude. Can it be enforced?
I don't know really what
Do you remember the Neponset case? Check your notes.
was that the HOA one, the
Yeah,
HOA
homeowners association. Yeah.
case?
What were the requirements? There were like 4 of them.
It has to there was like 3 of them. Actually, let me just look at my
There were a
notes.
few notes. It's a good review. And for those
Yeah, so
watching
you
at
would
home,
need.
you'll need to know the rules for equitable servitude.
Okay, so those 3 requirements are equitable servitude.
What are
Mhm.
they? Give it to me. please.
Okay, so intent that the benefit and or the burden of the covenant run to the successors, the covenant must touch and concern the land, and is there privity of estate? So I guess this wouldn't
Okay.
be an equitable servitude either, because lack of
So
privity of
let's
estate.
walk through this, right? These are from the Neponset, and there were 3 requirements for an equitable servitude, right? There has to be intent for the parties to be bound. The servitude must touch and concern the land, and there must be privity of estate. Now, I'll give you this for a refresher. You don't need horizontal privity. Okay? One of the requirements eliminated by this doctrine of equitable servitude is it doesn't need horizontal. You only need vertical. Okay? So that one's easy, right? There's vertical privity here, people running fee simple estates. Okay? Was there intent of the parties, Lindsay, to bind their successors here?
Yeah, they said 50 years.
Was there an intent of all the parties?
Was that the intent of all of the parties? Well, only 30 out of 39 people here.
Yeah. Then we come to the third one, Lindsay, right?
Okay.
Does this restriction of who can live on the land touch and concern the land?
Yeah, doesn't that just kind of, you're asking whether there's like a burden and a benefit whenever you're looking at touch and concern?
So this phrase touch and concern, remember from the Neponset case, wasn't very well defined, right?
Yeah.
It was not well defined at all. And generally what touch and concern means was some sort of obligation the person had to, not pollute, or the person had to not build a factory.
Right.
The Neponset case changed that and said, even if you have to pay some money, right, that touched and concerned the land. So I'd say that under the common law, the requirement of the race of the owner of a house in no way touch and concern the land. But under this Neponset standard, it basically means anything that affects the value of the land. So here's the crazy argument. Having African Americans living in the house, would that affect the value of the land? Probably. Therefore, there's touching concerns. There's also a requirement of notice, and that's where the notice comes in. I don't think everyone had noticed that that these covenants were present. So I don't think this could be enforced as a covenant. Under the common law, I don't think this could be enforced as an equitable servitude, but under the modern standard, it might be enforceable as an equitable servitude. Now, had the Supreme Court issued a decision saying, I remember one old property, right? And this is not an equitable servitude, this is not a covenant, it's not enforceable. That would not have been a very sexy holding. So instead, they decided to address the constitutional question, right? They decided to address the constitutional question, okay? And the constitutional question is this: is this action, right? Is this action something that the government can restrict? Or to state it differently, does the enforcement of this covenant run afoul of 14 minutes of Jared, right? Is the enforcement of this covenant unconstitutional? Actually, let me ask you a different question first, Jared. We'll get there in a second. Is it unconstitutional for neighbors to draw up a covenant that restricts the ownership based on race? Is that just to draw up in a covenant?
Well, the court ruling says yes, basically.
Yes. So merely drawing up a racial covenant, is there anything problematic about that?
About drawing that up?
Yeah. Just drawing up the covenant.
Yeah, are
there any legal problems with drawing up a racial covenant?
I'm trying to think how to word it, but it's the same as having, you have a business that is promoting some sort of racial policy. It's kind of the same concept.
Is that unconstitutional?
It
Merely to
is.
have a racial covenant and write it.
Only if you exercised it.
What do you mean exercise it?
Actually try to seek to enforce it.
And how do you enforce it?
By bringing a suit to someone that's violating it.
So if someone walks into your store and you throw them out because they're an African American, you don't physically throw them out, you just don't let them in the front door, right? If you do physical violence, that's a battery. I'm asking,
Right.
you see someone coming in, African American, you lock your door, you don't let them come into your store. Have you violated the Constitution in that case?
I guess so, yeah.
No.
No?
I don't really remember my
Yeah,
common
no.
law very well.
Well, no, this wasn't common, this you're reading for today.
No, that's a private agreement between private individuals, which they can do as long as the state's not enforcing it, then
Yes.
that's where it becomes problematic.
Right, so merely having a policy where you and your neighbors draw up a racial covenant does not violate the Constitution, right? Merely having a policy where you don't let people of a certain color into your store is not unconstitutional. The court here in Shelley says the problem arises when you seek the power of the state to enforce that. So to use the example I gave before, if you merely lock your door, right? If you merely lock your door and don't let a person in because of their skin color, you've not violated the Constitution. But if you call the cops and you say, I don't want this person entering my store because he's black or Hispanic or whatever it is, then you're enforcing state power. State actions involved, and that's where we run afoul of the Constitution. So David, why in this case was the Constitution violated? What did the neighbors do that brought them under the authority of the 14th Amendment?
Well, they used the legal system
To do what?
to enforce.
And how they try to do this?
I'm sorry?
How they try to do this? How they try to enforce it?
By
What exactly did they go to court to do?
to enforce
What did they seek in
to
court?
stop the
Yes.
to get them.
They saw an injunction. right?
Yes.
They saw an injunction. You had two neighbors who made a transaction for land, voluntary transaction, to sell this house to an African American family. The buyer was willing, the seller was willing, everyone was willing. But then the neighbors came in and said, we are the owners of this covenant and we want to seek an injunction to stop this. And generally, let's use a much more mundane and boring example. If there's a covenant restricting certain neighbors to building only residential, and then one neighbor says, I'm going to sell this to someone to build an apartment building, the neighbors could bring a suit for an injunction to stop that non-conforming use, right? However, this is the big however, Here, it will be the courts enforcing the racially restrictive covenant. And because the courts are involved, that's where we run afoul of the 14th Amendment. The courts cannot enforce a racially restrictive covenant because that would violate the 14th Amendment. Right? That is state action in violation of the Equal Protection Clause. Everyone with me so far? So Jared, after this case, can private clubs still be, only men? Or could an organization exclude people who aren't of the same religion or the same race?
Sure.
Okay, but what can't they do?
They can't use the power of the state to enforce that.
So what happens, Jared, if let's say you have let's say you have a club that only allows the people of a certain race, right? And then there's a dispute over membership. If someone didn't pay their dues. And they go to court and say, we're going to sue you for breach. You didn't pay your contractual dues. Can the court then enforce that contract, which includes a racial exclusion clause? In other words, can the court force the payment of dues to this club that itself is keeping out black people?
I mean, I think so, because it's not actually going after that.
But why
issue.
is it any different than the racial covenant? They're
Because
enforcing
that's not what they're seeking to enforce. They're just seeking to enforce something totally unrelated.
So the core of this is a contract with a racial restrictive covenant in it.
But the whole reason the suit was brought was to keep those people out.
Yeah, and this lawsuit, okay, someone brings a suit saying, admit me to this club, I have this contract, and they'd be forced to be admitted.
I mean, I'm not really sure what you're asking, as far as what contract they bring to get in the club.
I was kind of thinking what he was thinking, like if you're just suing for payments, it's not like you're suing over the fact that
Yeah,
this
if I was
is a
a man,
non.
if I was a man that was already in the club and was suing over payment, it's
But
not
the
related at all.
contract itself has this provision in it, can courts even entertain such a contract?
Probably not then, if there, I don't know, I liked what he was saying. What he was saying was making sense, but now what you're saying
Yeah,
is
that's how-
kind of
that's how
making sense
professoring
too,
works.
so I don't know.
Yeah, that's how professoring Socratic works. So,
Yeah.
there are a lot of unanswered questions by this case, right, where you do have many private associations that do engage in discrimination, or you may call it association, whatever word you want to use, where they exclude people of a certain race, gender, sexual orientation, whatever it happens to be. And does the mere fact the court is enforcing this make it an unconstitutional contract? So this comes up in the context of religion. So say you have a church that employs a teacher at the Sunday school, and the teacher gets a disability, seizures, and the church fires the teacher, saying, "Look, we don't want to deal with your seizures anymore." Now, if any private employer did that, there'd be lawsuits brought under the Americans with Disabilities Act and other similar provisions. But can a court get involved in the decisions of a ministry, of a church? Can they make this? Can they say, no, you can't fire this person? And this comes up quite a lot. The courts have generally said when you have these religious institutions, they are largely going to be exempt from general discrimination laws because of the importance of religious autonomy, that we don't want courts messing with the internal workings of a church. The somewhat easy answer for you, though, about all this is Shelley v. Kraemer doesn't have much relevance today. And the reason why is in the 1960s, Congress enacted the Fair Housing Act. And the Fair Housing Act, I think is referenced somewhere in your readings, makes it illegal to have racially restrictive covenants under a statute, not under the Constitution. So for whatever reason you deal with a piece of property that has a restrictive covenant, it breaks federal law, and it's not going to be enforced for that reason. But the reason why Shelley v. Kraemer was important in the 1940s was that this was very early on. This was 5 years before Brown v. Board of Education. This was 2 decades before the Civil Rights Acts, 2 decades before the Housing Acts. So this was done as an intermediary measure. Now, as far as I've read, this decision didn't have much force. Neighborhoods continue to informally enforce these racial covenants. And I'm certain that if any of you checked around homes in Houston and looked back, you'll find them in the records. I'm positive about this. They'll be recorded back in the day. Now this one was only good for 50 years, so I suppose it expired sometime in the 1990s, or no, I guess it was the 1960s or so, right? The case from the 40, whatever. But the covenant was in the 1930s, so I guess sometime in the 1980s the covenant would have run its course. But the lesson here is that state action is fairly broadly enforced in the context of racial restrictive covenants. Okay, so any questions on Shelley? Questions on Shelley? No? All right, let's go on to the next topic then, a lot less sexy. The next topic is about termination of covenants. That is, a covenant that was properly created. You had horizontal privity, you had vertical privity, you had all the requirements met. But under what circumstances can courts step in and say, we are not going to enforce this covenant anymore? So the book identifies 9 different circumstances under which a covenant ceases to exist. The first one was called merger. Merger. When the benefit and the burden are owned by the same person, the covenant vanishes. And if you recall, we did this with an easement question like a week or two ago, right? When the same person holds both the benefit and the burden, it disappears. Because it makes no sense for one person to have a covenant against himself. So if you want to get rid of a covenant, what you basically do is buy off the land that's benefited, and then it disappears, right? Even if then you buy it and it disappears and you sell it immediately thereafter, the covenant does not return. You'd have to create it anew. A second way to terminate a covenant is what's called a release. And this is a phrase you'll use in law a lot, where you basically pay someone to let you go, right? So you find the party that's benefited, and then you give them a lot of money, and they release you from the obligation. That instrument is then recorded, and it takes the effect of nullifying the covenant. Okay? And that's binding not only on the person who released you, but that person's successors. Because the base says, I am going to sell this land now without the covenant attached to it. Okay with that one? The third one is a phrase called acquiescence. Acquiescence. And this happens when the plaintiff fails to enforce the covenant after a breach, right? So let's say the covenant says you can't build a factory here. And for all these years, you had a factory running and you never said anything. And then suddenly, the plaintiff seeks to enforce the covenant. You can actually claim there's acquiescence, that he basically gave into it. Now you may ask, isn't that like prescription, right? Very similar. If you keep doing something, and the person knows about it, takes no action, you gain the right. The difference between acquiescence and prescription is it's not as formal, right? You don't have to show a specific time period. You don't have to show hostility. What are the other requirements? A little bit easier to satisfy. Okay. There's also the concept of abandonment. Okay. Abandonment is exactly what it sounds like. If a person abandons a piece of property and doesn't ever use it, and gives up on the covenant, courts won't enforce it. And you say, Josh, isn't that like prescription? Yes, it is. It's very similar. So the acquiescence and abandonment have similar provisions. Now, there's a fifth doctrine called unclean hands. This is an equitable principle you see over and over and over again. What are unclean hands? Let's say the covenant says that for an entire subdivision, you can only build residential, you can't build commercial. Okay, fine. What if it turns out that the plaintiff himself had built commercial developments? And then suddenly says, defendant, you can't build this commercial stuff. You say it's unclean hands. Any questions so far? There's a sixth one, another equitable defense, which you'll see quite a lot, which is called Laches. It looks like L-A-C-H-E-S, but it's pronounced Laches, not Laches, Laches. And this doctrine basically says if the plaintiff waited too long to enforce a servitude, the doctrine of Laches bars enforcement. You can't wait too long. This is a general notion that if you have a remedy, bring it to court right away. Now, this is not like a statute of limitations, right? This is not like a strict statute of limitations. It's more of an equitable concept, which doesn't have a strict beginning and end. That's number 6. Number 7, this is David Letterman, right? Number 7, estoppel. Okay, estoppel. This is our general fairness one. If the defendant relied on the plaintiff's conduct, it'd be inequitable to allow the plaintiff to enforce it. So, let's say the covenant said you can't build commercial, and the defendant asked the plaintiff, hey, do you mind if I build a factory? He's like, no, go ahead, build it. And he relied on that promise and built the factory. The plaintiff can't then turn around and sue for it. Again, estoppel is always equitable, and it's up to the court's good graces. Number 8, eminent domain. We will talk about this later in the year. But eminent domain is a process by which the government takes property for public use and provides just compensation. So if the government seizes your property by eminent domain to build maybe a railroad or a highway or a hotel in some cases, I suppose, that extinguishes the easement or the covenant, right? That extinguishes the covenant. Ditto from prescription. If you obtain a piece of property by adverse possession, you wipe out any covenant. And why? There's no vertical privity, right? One of the requirements for a covenant is vertical privity. If you acquire it by adverse possession or prescription, you're getting a new title. There's no privity there. And finally, number 9. Should be the 10th one, but there's not. Changed circumstances. This is one of the subject of our last 2 cases for today. If a court finds that circumstances have changed, such that the original motivation for the policy is no longer valid, the covenant will no longer be enforced. But this is a fairly rigorous standard, and courts will continue to enforce it so long as generally someone's benefiting from it. If there's even one party benefiting from the covenant, they will continue to enforce it, even if it makes no sense, right? And even if one person is being unreasonable, and even if the community as a whole would be much better off if the covenant was not enforced, they continue to enforce it. And that's the topic in the final 2 cases for class today. Any questions on that rundown of 9 things? See, if there was a full class, I would ask people to do 1 through 9, but I'll spare you that. All right, I forgot where I was. David, give me the facts, please, in a Western Land versus Truskolaski from Nevada, 1972.
Okay, 1941, the Western Land Company, they had a 40-acre tract of land,
Okay,
and they subdivided it in Reno.
good.
They subdivided it for residential use. And each lot was subject to a restrictive covenant, and which forbid the use of the property for anything other than single-family homes.
Very good. Okay. So what happened some decades later?
Okay, well, at the time, it was like primarily residential and agricultural, but over the years, there's a lot of growth. There was substantial commercial development.
Good.
That was occurring nearby. You know, restaurants and shops.
Uh-huh.
Around 1968, Western, they wanted to build a supermarket on a 3.5 parcel in the subdivision. And in response to homeowners, the plaintiffs in the subdivision sued to enjoin the development because, arguing that it violated the restrictive covenant.
Covenant, good.
But what Western argued was that the character of the area had so substantially changed since 1941 that the restrictions should no longer be enforced.
Very good.
And I think that they pointed out the city council had even considered rezoning
Good.
the parcel, at the parcel at issue for commercial use, but they didn't do that.
They did not. David, what do we make of the fact that the city considered rezoning but didn't? What should we take from that?
I think it's significant that even the city itself saw changes.
But they didn't do it though. I mean, generally, what do we do if Congress considers passing a bill but doesn't pass it? What sort of inference should we draw from the fact that Congress or some legislature doesn't do something?
The times are changing.
The times haven't changed. If they're not gonna change, yeah.
If they
Oh, okay,
didn't
okay.
do it,
Yeah.
if they didn't do it, maybe they thought, oh, maybe we should leave it alone. So it's always difficult, and I'm guilty of this, same as anyone else. When you try to draw an inference from inaction, right? Congress considered X but didn't do it. What should we draw from that? And I think you can go both ways. I think David, you have a point. I think Lindsay has a point, right? They didn't do this. Maybe they thought the neighborhood hasn't changed so much. What else can you do from that, Lindsay? The fact that the neighborhood could rezone the neighborhood, what does that tell the courts? What message does that send to the courts if the zoning board is able to consider it?
That people are wanting it to be changed, like.
And then which branch of government should be responsible for that?
I guess the legislative branch, right, rezone.
Because if the city is capable of rezoning the neighborhood, why should the courts get involved?
To enforce, I guess to enforce, to make sure that people are complying with the zoning restrictions that the
But
law.
is it, what's at issue, a zoning restriction or a covenant?
Covenant,
So even if the city changes the zoning, what's it to the covenant?
the covenant stays.
Yeah. So here's the rub, right?
Ah,
Even if the zoning changes for the neighborhood, the covenant remains in force. You always enforce whatever's more strict, right? So say the zoning changes to allow commercial development. So long as a covenant's in effect, you continue to enforce the covenant, right? That's why these guys went to court, because they realized even if they were successful in getting the zoning changed for the neighborhood, they'd still be bound by the covenant. And that's why they had to beg the court to release them from this covenant. So Jared, what did the court do here with this covenant? They find that they were going to release them from it and find that it was terminated.
If they what, I'm sorry?
What did the court do here with the covenant? Did they release the parties from it?
No.
Why not?
Because that, they didn't think that, they thought that the policy was still good.
Why do they think it was still good? What sort of rationale was provided by the court?
They talked about kind of the makeup of the neighborhood and how houses are still being maintained there. And
Who are they thinking about? Always most important in any case.
the homeowners.
Specifically, which individuals in the home do they think most about?
Which individuals in the home?
Yeah,
I'm not really sure.
David? Who are they thinking about the most, always in these sorts of cases?
Children?
Children!
Oh,
You ever watch The Simpsons, Helen Lovejoy? Won't someone please think of the children, right?
I'm a Simpsons fan.
Good, at least one we got it. Children. In any of these cases, I promise you, where courts are considering whether to change a covenant, the most important thing is, won't the kids have a safe place to walk outside and play on the street? You know, little Johnny and Sally, right? Won't they be able to, play ball, stick ball on the street, whatever it is, right? That's always their concern. So because you have these single-family homes, you need a place where the kids can go, play and run around the street, whatever else, right? And as a result, they find that the covenant shall remain in force. It has not outlived its usefulness. And even if it's more valuable than residential, right? Even if commercial is more valuable than residential, they're going to enforce it. This is like the opposite, though, of some of the nuisance cases we did. Where, you know, in Boomer, for example, they said, well, if we shut down this factory, we're gonna put all these people out of business, so maybe we should consider keeping the factory open and allow him to compensate for the damages. The covenant was the exact opposite. It doesn't matter how much money will be made from these businesses. What matters is you enforce the damn contract and their pre-existing rights. Make sense? Is there any questions on the second case, on the Nevada case? I wish I had 3 people in my normal classes. See how quickly we're going also?
Yeah.
Like, you never think of how much of class is spent otherwise, but it's a lot quicker. Okay, I'll leave it at that. Any questions on the Nevada case? All right, I forgot who's next. David, you go back, I think, yeah. Or Lindsay, you're next.
Yeah, I just said.
He just won.
Okay, you're next, okay, I can't.
I'll
You'd think
go.
with 3, you know how valuable it is for me to go up and down the roads, because it's actually very easy. Here you're staggered, it's confusing. Lindsay, give me the facts in Rick versus
Okay.
West, New York case from Westchester County.
So Rick's owned 62 acres of land, which there was a restrictive covenant on, and the restrictive covenant just said it had to be single-family houses.
Good.
And so he sold a half-acre lot to West, and she built a home on it. And then he wanted to sell like the remainder lots, and at first he tried to sell it to some industrialist, but West refused to release the covenant,
Good.
meaning it still had to be family-friendly or whatever. And then he also tried again to sell it to a hospital, and again, West refused to release the covenant. And so Rick's is trying to argue there was a change of condition and the covenant's no longer valuable. And the trial court actually found in favor of West.
Okay, very good. So this is a similar case, right? Where you had a subdivision. The subdivision was imposed to impose requirements for single-family dwellings. And West purchased the house with the understanding that not only her lot, but the lots around her would be restricted to single-family dwellings. But here we have the problem what's called a holdout. A holdout. Where everyone on the subdivision agreed to go along to sell the land for the hospital or whatever, except for one person. And I put some pictures up on the class blog of some famous holdouts. So anyone ever see this picture? It's exactly what it looks like.
Oh my God.
You have
Oh, wow.
you have a house that the person wouldn't sell their lot, and then with an LA Fitness is they actually literally built it around the house. They couldn't get the guy to move.
Wow.
And you can see it also here, where they have this humongous development in like a little lot right there because they couldn't build in that one lot. And there's another one over here. This one's, yeah, you can see it better from this angle. So you have this massive structure, right? And you build around. But the holdout problem is real, because if the person has a covenant and they don't release it, you don't have much of a choice except to build around it and hope you make their lives miserable enough that they eventually move out, which is probably what will happen. You have this massive structure like towering over your house. But here, the court, Jared, what did the court do with this covenant? Did they continue to enforce it?
Yes.
Why did they continue to enforce it?
Because they found that it's, what does it say? They quote the Cardozo opinion.
Good, yeah, was Judge, it's actually Judge Cardozo, because on the New York Court of Appeals, they're not justice, they're judge. In New York, it's a weird thing. The highest court in New York is the New York Court of Appeals, and the trial court is the Supreme Court. And the reason why it's the Supreme Court is they have general supreme jurisdiction. So the trial court judges are called justice in New York, and the highest courts are called judge. So it was actually Judge Cardozo on the New York Court of Appeals. So what did Judge Cardozo say?
Yeah, I mean, he talks about basically balancing the equities between, obviously, the plaintiff's interest, and specifically would be in the installation of a hospital here, and talks about the defendant's equities, but he says that the defendant, the owners, done nothing but insist upon adherence to a covenant which is now as valid and binding as at the hour of its making. So they...
Very good. This is a case where no matter how much benefit a hospital will bring to this neighborhood, and it'll probably bring a lot more benefit than this one person's house, they will continue to enforce the covenant, right? If this is so important to the hospital, everyone has $1 that they'll be bought for, right? Or maybe not. Does everyone have a price that they'll be bought for? If you look at these houses, I suspect the answer is no. Some people are so wedded to their property that no dollar amount will work. And I'm sure they tried to buy this person off, they buy them off. Now, what often happens is they'll simply use the power of eminent domain to force them to leave and have the government condemn the property. We'll say this later this semester with the Kelo case, where you had the Pfizer Corporation tell the city of New London, Connecticut, hey, we want to build a waterfront research facility right by the river in New London, Connecticut. I visited there. And most of the homeowners were sold, but one of the homeowners refused to. And so instead the government said, we will simply seize your property by eminent domain. And this case went all the way to the Supreme Court, and the court eventually ruled against the property owner that their house has to be taken, even though it was for private development. But at least here, they enforce the covenant, they find there's no change, at least one person benefits from it, and that's enough. Okay, so any questions on these cases? Yeah, David?
What about like, okay, so, like in that picture right there,
Yeah.
the person lives there, and what about like nuisance, because can the person say like, hey, I was here way before you guys were, what might happen?
Well, I think there might be a sunlight or some sort of light and air nuisance as well. I suspect they paid for the right to block their sun. Because, again, under Boomer, if you commit a nuisance, you pay the person for it, but you still build, right? You don't get the injunction anymore. This is not like the old approach where you get an injunction. Here, you just get a nuisance for damages. But again, they won't release the covenant. The person won't sell. You can't force them to. That's his Blackacre. That's his lot. As tiny as it is, right? This little bungalow house.
So if they are gonna get damages, it would most likely be on the theory of nuisance.
I suspect there's blocking of sunlight. I mean, I can't really
Okay.
tell from the picture, but I guess there's air and light problems as well. Yeah, this other picture, and in this picture, the house is boarded up, which I'm not even sure what the deal is with that one. Right? But these things happen.
Who would live there?
No, you wouldn't want to live there, of course
No,
not. But
absolutely not.
Someone obviously does.
Or there, I just, ugh.
Yeah, I think this actually is a before and after picture. I think these are the same houses. I can't remember because they look pretty similar. With this little beat up car up front. Anyway, all right. So questions on the third case. So the general rule is that covenants will continue to be enforced, and that courts are very hesitant to terminate them based on the changed circumstances doctrine. That is, so long as at least one person is still willing to enforce the covenant, that's enough. That's enough. Okay. Questions in that case? David, we have plenty of time. Do you have some questions you want to ask?
Well, it wasn't related to
Oh, okay.
something.
You can ask after class. Okay.
Another topic.
Okay. Is there any objection to ending class early today?
Not at all.
None? Jared? David? Okay, very good. All right, my friends, thank you so much. I will see you. We do not have class on Tuesday. I will not be in town. So you have that day for yourselves, and I'll be back on Thursday. I'm already underway in the midterm, so we'll be grading them hopefully soon.